Hi, and welcome to this latest immigration law update video. In this video, I want to give a version for everybody of a webinar I've developed based on my immigration law images. If you follow me on social media, I've been posting some quotes from different cases as images and sharing them on social media. And I thought it'd be a good idea to go through some of those images and talk about the issues they cover. So I've called this webinar Quotes from Classic Immigration Cases, Old and New. And I'll try and put the slides online so you can download the slides if you haven't seen my images. So the first issue I'm going to cover is one of deportation in Article 8. Following KO Nigeria, the focus when looking at whether a deportation decision was unduly harsh on a partner or a child was on that partner or child alone, and it wasn't a balance of the criminality. And what we saw in the last couple of years is the upper tribunal and the Court of Appeal overturning a lot of decisions that are in respect of allowed appeals, saying, well, this is not truly unduly harsh. There's nothing out of the ordinary in this case. And what we've seen in recent months is the Court of Appeal restoring the balance a bit, particularly in the case HA Iraq, that's 2020 EWCA Civ 117. And there was a couple of cases that followed HA Iraq. One of them was AA Nigeria, and you'll see that cited at the bottom of the slide. And the other one is KB Jamaica. And this is a quote from KB Jamaica and paragraph 15, which is a brilliant summary of the law in relation to undue harshness. This was a case of somebody who got an 18-month sentence, had 4 British children, and the first tier tribunal had found that deportation would be unduly harsh. That had been overturned by the by the upper tribunal, but the Court of Appeal restored the allowed decision of the first tier tribunal. And it says this in the quote: the formulation in paragraph 23 of KO Nigeria does not posit some objectively measurable standard of harshness which is acceptable, and it is potentially misleading and dangerous to seek to identify some ordinary level of harshness as an acceptable level by reference to what may be commonly encountered circumstances. The danger is actually in looking for something out of the ordinary. You're actually applying a sort of exceptionality test beyond that of unduly harsh. They go on, there is no reason in principle why cases of undue hardship may not occur quite commonly. So actually, it could be a common occurrence that you succeed in a deportation appeal on the basis of undue hardship. And how a child will be affected by a parent's deportation will depend almost on an infinitely variable range of circumstances. It is not possible to identify a base level of ordinariness. So obviously you'll have to identify in your case the individual circumstances, how that child, how that partner would be affected, and how it would make the deportation of their parent or partner unduly harsh. And if you're challenging a decision, maybe the tribunal has said, well, there's nothing out of the ordinary, and you can use this quote in order to challenge that decision. Let's go to the next image, and that concerns 276B, the 10-year-long residence rule, ILR, and overstaying. There's been a lot going on in this area over the last few years, and it particularly concerns Rule 276B Roman 5 and the disregards there. And it allows somebody to apply as an overstayer as long as 39E applies. And there's also then a disregard to historic gaps in residence that were either before a certain date below 28 days or after a certain date where 39E applies. And there were 2 cases, one from the upper tribunal, Junaid Ahmed, and one from the Court of Appeal called Masoom Ahmed, where it was said that these disregards can't be relied upon in respect of establishing 10 years lawful residence in the United Kingdom. Now, in Hock and others, Lord Justice Underhill gives the lead judgment, and he finds that, no, you can't rely on that period of being an overstayer to establish your 10 years lawful residence. The first disregard, what he calls open-ended overstaying. But you can rely on the second disregard, which refers to these historic periods and gaps which were covered by the long residence policy and the Home Office always allowed for, because otherwise the rule makes no sense. So Masoom Ahmed was wrongly decided and Junaid Ahmed was correct in terms of it applying, you can't rely on being an overstayer now, to the first disregard, but it was too wide where it applied to both disregards. So if you've got these historic gaps that were covered by the Home Office policy, you can rely on them to build up your 10 years lawful residence. Again, changing subject again, a really helpful decision called Mix M Gender Identity, HJ Iran Terminology, El Salvador 2020, UK UT 313 from Appetite Tribunal Judge Bruce. There's a national of El Salvador, previously identified as a homosexual male. Asylum claim failed and appeal dismissed. And then as time passed, the appellant changed their identity and was now identifying as non-binary, and their appearance had changed significantly, made a fresh claim. And again, the judge dismissed the appeal. But the judge didn't properly consider the appellant's current identity and didn't look through the lens of HJ Iran. And Upper Tribunal Judge Bruce found, applying HJ Iran, that there was an error in the decision, that the social group the appellant belonged to hadn't properly been analysed. And then she went on to reconsider the case and found the appellant would be at risk when looking at the case through the lens of HJ Iran. However, they were viewed in El Salvador, whether as a homosexual male or whether as non-binary, they would be at risk, and their case succeeded. So the head note says this: decision makers should, where possible, apply the guidance in the Equal Treatment Bench Book and use gender terminology which respects the chosen identity of claimants before them. The principles in HJRR are concerned with the protection of innate characteristics. As such, they're to be applied in claims relating to gender identity. Let's again change subjects and go to trafficking. There's definitely something for everyone in this webinar because we're covering the whole range of subjects and NRM decisions. This was an application by somebody who previously had leave to remain under Tier 5, then made a claim under the NRM, a trafficking claim. There was a positive reasonable grounds decision, but their leave, their Tier 5 leave expired while they were waiting for their conclusive grounds decision. There are huge delays from the Home Office in making conclusive grounds decisions. Have a look at paragraph 27 of this case, the case of EOG. This is 2020 EWHC 3310 from Mr. Justice Mostyn. And he says there that the mean number of days for a decision at the time he was writing was 462. That's for a conclusive grounds decision. And in fact, I've used those statistics in bail applications recently where we've got a positive reasonable grounds decision and saying, well, look, there's likely to be a huge delay now before a conclusive grounds decision. This JR was successful because it was a challenge to the Secretary of State's policy, and it was found that there was an unlawful lacuna in the policy because what it didn't do is provide for an interim grant, you'll see there, of discretionary leave, which may give the person also the permission to work, because these people, perhaps particularly in the claimant's case where they applied with leave to remain and a right to work, there's huge delays and they're going to be prejudiced by that. And the Secretary of State should have a policy to consider whether in certain circumstances to grant discretionary leave in the interim or a right to work. Let's have a look at sponsor licenses and fairness in a case that got all the way up to the Supreme Court, a case of Pathan. In fact, the Supreme Court were unanimous on one issue, but split on the other. It was a Tier 2 application, and while the appellant was waiting for a decision, his sponsor lost their license. And then 3 months later, the Secretary of State refused the case on that there wasn't a valid certificate of sponsorship. He applied for administrative review on the basis, well, I should have been given 60 days on a fairness basis. That was then went to judicial review and ultimately made its way up to the Supreme Court. And the Supreme Court were unanimous that the Secretary of State had breached her procedural duty and should have notified the appellant that the sponsor had lost their license so he could do something about it. So it says this in paragraph 107, underpinning the duty to act fairly in this context is the notion that a person such as Mr. Pathan should be afforded as much opportunity as reasonably possible to accommodate and deal with a decision which potentially has devastating consequences. One only has to envisage how Mr. Pathan must have reacted to the news that his Tier 2 application had been rejected because of the revocation of Subramania's license, that's the sponsor, his employer, to understand the fundamental justice in giving him the chance to do something about it. He had every reason to believe that his application would succeed. The reason that it did not had nothing whatsoever to do with him, but failure in the application represented a calamitous upheaval for him and his family. To ensure in those circumstances that he had timely notice that for wholly unanticipated reason his application was bound to fail, so that he could seek to avoid its consequences, seems to us to be a self-evident aspect of the duty to act fairly. So the Secretary of State should have given him notice, but the Supreme Court was split and the majority held that the Secretary of State didn't have to grant a period of leave. So they had to notify, fairness required a notification that your sponsors lost their license, but there didn't need to be a grant of leave. A helpful paragraph is paragraph 104. It's not on the slide, but do have a look at paragraph 104. Let's have a look at Zamorano Cares and a case that came before the Supreme Court, that of Robinson, Jamaica, from 16th December 2020, UK SC 53, and a primary care of a UK child. Ms. Robinson had a conviction for dealing in Class A drugs, and the question was, could Zamorano Cares be deported? There had been some recent cases of the Court of Justice which are referred to in this case, and they talked about in exceptional circumstances, a Zamorano carer could be deported. Now, in Robinson, the upper tribunal had held that there was absolute protection from deportation for a Zamorano carer. So the appeal was remitted by the Supreme Court in this case on the basis that a Zamorano carer could be deported, and the question was there an exceptionality test based upon those words of the CJEU? And this is what the Supreme Court say. When seen against the background of the analysis beginning at paragraph 34, it is clear that the CJEU did not add any additional criterion through the use of the words exceptional circumstances. On the contrary, and as the Court of Appeal correctly decided, it was simply explaining that in the prescribed circumstances, an exception could be made to the general rule that a Zamorano carer could not be compelled to leave the territory of the Union. It was not stating that certain undefined exceptional circumstances had to first be demonstrated. So there's not an exceptionality test, but as an exception to the general rule, a Zamorano carer can be deported. What about qualifying children? Is it reasonable for a qualifying child to leave the United Kingdom? When I talk about a qualifying child, in section 117A to D of the 2002 Act, it talks about qualifying children as 7-year children or British children. These sort of questions coming up when we look at section 117B6 of the 2002 Act, perhaps in a partner case under EX1A, or a child may be applying, a 7-year child, under 276 ADE Roman 4. And this is an extract from the Secretary of State's guidance, Family Life as a Partner or Parent, Private Life and Exceptional Circumstances. Now, the quote I've put when I made this immigration law image was from version 11 from the 16th of October 2020. There is now a new version, I think it's version 13. It was published on the 28th of January 2021, this year. So have a look at pages 51 and 52, but the extract is exactly the same. So the starting point in respect of qualifying children is that we as the Home Office in this case, we would not normally expect a qualifying child to leave the UK. It is normally in the child's best interest for the whole family to remain together, which means if the child is not expected to leave, then the parent or parents or primary care of the child will also not be expected to leave. So that's an important quote. And when you're doing your representations, or your appeal skeleton arguments or grounds in cases involving qualifying children, this is the starting point of the Secretary of State. Now, as you know from cases like AB Jamaica, you consider whether it's reasonable, whether the child would actually leave or not. Because in a lot of cases, the child wouldn't actually follow the parent, but you still consider the hypothetical question of whether it's reasonable. But that assessment must be done in the real world context. So a parent's immigration history may be relevant in the assessment in the real world context. Now let's change subjects, and we're going to, the next two slides deal with a case called Uddin. From the 12th of March 2020, the appellant in this case was born in 1999 in Bangladesh, and he was trafficked to the United Kingdom as a teenager, found abandoned on the streets in London, was given leave as an unaccompanied minor, and made an asylum or Article 3 and Article 8 claim. And ultimately that was refused, and that came for appeal, by which time he was an adult. The judge didn't believe his Article 3 claim, and also on that basis then rejected his Article 8 claim, which was on a separate basis altogether. That was on the sort of undisputed evidence of his close relationship with his foster carers and the foster family. Now, the first thing I want to look at from this case is, just because the appellant may have been untruthful in relation to his Article 3 claim doesn't mean he was being untruthful in relation to his Article 8 claim, of which there was sort of credible evidence which stood alone. And what the Court of Appeal say, which is really helpful, is they use a principle called a Lucas direction derived from criminal cases. So the Court of Appeal say this: I note that in regard to the conventional warning which judges give themselves that a person may be untruthful about one matter, in this case his history, without necessarily being untruthful about another, in this case the existence of family life with the foster mother's family, known as a Lucas direction, derived in part from the judgment of the Court of Appeal Criminal Division in R.N. Lucas from 1981 and the Lord Lane, the Chief Justice. The classic formulation of the principle is said to be this: if a court concludes that a witness has lied about one matter, it does not follow that he has lied about everything. A witness may lie for many reasons, for example, out of shame, humiliation, misplaced loyalty, panic, fear, distress, confusion, and emotional pressure. That is because a person's motives may be different as respects different questions. The warning is not to be found in the judgments before this court. This is perhaps a useful opportunity to emphasize that the utility of the self-direction is of general application and not limited to family and criminal cases. So we can use this in the immigration context. So if you've got a case before the tribunal that has, say, an asylum aspect and an Article 8 aspect, just because your client's been untruthful about one aspect doesn't mean they're being untruthful about the other. So it's something you may want to raise, say, in closing submissions in an appeal. Or perhaps if you're challenging a decision and a judge has said, well, you've lied about an asylum, so therefore I don't believe you're in a genuine relationship in the UK, where actually they're different issues and there may be standalone evidence that needs to be considered. Uddin went on to give some great principles about adult Article 8 relationships and the relationship particularly with adult children. What had happened in the upper tribunal in Uddin is the deputy upper tribunal judge had also sort of introduced this concept that a foster carer relationship was different because there was this sort of commercial element to it. So this is really helpful principles for you. The test for the establishment of Article 8 family life in the Kugatha sense, so this is when we're dealing with adults, is one of effective, real, or committed support. There is no requirement to prove exceptional dependency. And you'll still see that cited in refusal letters. Oh, well, you haven't showed there's anything exceptional about the relationship. The test for family life within the foster care context is no different to that of birth families. The Court of Tribunals looks to the substance of the relationship, and no significant determinative weight is to be given to the formal commerciality of a foster arrangement. It is simply a factual question to be considered, if relevant, alongside all others. The continued existence of family life after the attainment of majority, so after you turn 18, is also a relevant question of fact. And I like this, this is important. No negative inference should be drawn from the mere fact of attainment of majority. So just because you've turned 18 doesn't suddenly mean that family life is turned off. While continuing cohabitation after adulthood will be suggested of an ongoing, real, effective, or committed support, which is the hallmark of family life. So actually, living together even after you've turned 18 is a good suggestion that you still are part of the family unit and there still is family life. What about credibility? Credibility is so often the key issue, particularly in asylum claims. In the case of MN, a comprehensive case from the 21st of December 2020, the Court of Appeal considered the NRM, the National Referral Mechanism, and trafficking. The main challenge in this appeal was about the standard of proof and whether people should still benefit from the benefits if they've got a positive, reasonable grounds decision, even if they failed on the conclusive grounds at the balance of probabilities test. The Court of Appeal rejected that, but go on to give some really helpful guidance on credibility. And in fact, if you look at paragraphs 121 and following, there's some really helpful stuff on summarizing the approach to credibility and expert evidence. So when you've got experts, say a scarring expert or another type of medical expert who comments on the appellant's plausibility or credibility, how should that be applied to the assessment of the credibility of their claim? Some really helpful stuff. And here at paragraph 127, Lord Justice Underhill says the term credibility is used a good deal in the context of both asylum appeals and of decisions of whether a person is a victim of trafficking. And we've detected a tendency to treat it as having some special technical meaning. But in truth, it connotes no more than whether the applicant's account is to be believed. In making that assessment, the decision maker will have to take account all factors that may bear on that question. So if you're challenging a decision, has the decision maker looked at all factors that bear on the question of credibility? For example, an expert report or a country report. Likewise, the term plausibility is not a term of art. To say that a particular account or element in that account is implausible is simply to say that it seems to the decision maker to be inherently surprising or the kind of thing that you would not normally expect to happen. And such an assessment will obviously feed into the overall assessment of credibility, that the weight to be given to it will depend on the degree of unlikelihood and how confident the decision maker can be about it. Perhaps both points are too obvious to need making, but if terms are used too regularly, they sometimes get in the way of the process of common sense decision making. So there's some really helpful guidance in this case on the approach to credibility. And if you're challenging a credibility decision, have a look at MN paragraphs 121 and following. But new matters. You may know that in section 85, there's a prohibition on the tribunal considering new matters, and a new matter is a new factual circumstance which amounts to a ground of appeal, that they can't consider it without the consent of the Secretary of State. Now in Birch is a really interesting case for a number of reasons. Miss Birch came into the United Kingdom in 1999 as a visitor. She had leave until 2001 in different capacity. Then in 2000, she was an overstayer then in 2007, 2008 time, she paid somebody £3,000. They were posing as an immigration officer, and she was given what she thought was indefinite leave to remain. Now, in this case, it was accepted that her intentions was genuine. She wasn't in any way complicit in any fraud. She was a victim in this case. She was genuinely deceived. In 2015, she applied, I think, for a driving license, and then this all came out and she realized she didn't have indefinite leave after all. So she applied for leave to remain, and her appeal was dismissed by the first tier tribunal. It came on appeal to the upper tribunal in front of, I think, the president and the vice president. And they set aside the decision of the first tier tribunal, relying on the Supreme Court case of Aguiarco, and particularly paragraph 53 of Aguiarco, where Lord Reed talks about taking a less strict approach in a case where somebody is mistaken about the fact that their presence in the UK was precarious. So between 2007 and 2015, Miss Birch thought that she was settled in the United Kingdom and built up her private and family life thinking she was lawfully settled here. And the upper tribunal found that that probably wasn't taken into account, and a less stringent approach should have been taken following Agiaco. Now, by the time the case was in the upper tribunal, she had passed 20 years in the United Kingdom, thus meeting the requirements of 276 ADE. The presenting officer argued to the upper tribunal, well, hang about, that's a new matter. You can't consider that. And Mr. Ockleton looks at the statute and looks at the definition of the phrase the tribunal in part 80, section 81 of the Act. And he says the tribunal means the first tier tribunal. So the upper tribunal are not constrained by the new matter provision. So we don't need your permission, Secretary of State. We're a superior court of record. We can take all matters into account, and they allow the appeal. This is really interesting if you've got a case where you've gone to the upper tribunal, the decision's been set aside, and perhaps there's been factual developments, perhaps there's been a birth of a British child. And so in the past, you may have asked for your case to be remitted back to the first tier tribunal, but actually there may be good reasons to then keep that case in the upper tribunal. I just talked about somebody meeting 276 ADE and the 20-year rule. One of the other provisions in 276 ADE Roman 6, this only applies to adults, is whether there's very significant obstacles to integration. And that's quite a high test. And in a case called Trabarwan, forgive me if I mispronounce that, the president, Mr. Justice McCluskey, when he was president, had found that mere inconvenience, mere upheaval, even when multiplied, couldn't amount to a very significant obstacle to integration. But in Parveen, Lord Justice Underhill says, well, that's not a helpful observation. He says this: it is fair enough to observe that the words very significant connote an elevated threshold, and I have no difficulty with the observation that the test will not be met by mere inconvenience or upheaval, but I'm not sure that saying that mere hardship or difficulty or hurdles, even if multiplied, will not generally suffice adds anything of substance. The task of the Secretary of State or the tribunal in any given case is simply to assess the obstacles to integration relied on, whether characterized as hardship or difficulty or anything else, and decide whether they regard them as very significant. So what are the obstacles in this case to integration, and are they very significant? So I still find the Secretary of State will cite the Trabarwan case, and I've had it cited in appeals, and this will be a good case to rely on if you're arguing very significant obstacles to integration. Now, the very significant obstacles to integration is also a test in deportation in exception 1 in 117C of the 2002 Act for somebody who's lawfully lived the majority of their life in the United Kingdom. And a recent really interesting deportation case is the case of Lowe, a Jamaican national, came here aged 3, and I think just before his 18th birthday got convicted of possession with intent of Class A and possession of a bladed article. I think he got 2 years, 4 months in prison. And his appeal was allowed by the first tier tribunal, who found there were very significant obstacles to integration. That was overturned by the upper tribunal. And then it came before the Court of Appeal, who by a majority allowed his appeal and restored the decision of the first tier tribunal. So another one like those early cases we talked about, A, Nigeria and KB, where we've seen restoration by the Court of Appeal of allowed first tier decisions. Now, it's really interesting because of a number of reasons, because actually the facts weren't that stark in this case. And also there's this interesting of this notion of exile. So Lord Justice McComb says this: it was, in my view, quite open to the FTT judge to find that they were the necessary, very significant, based on the impression made upon him as to the effect of the exile of this young man. So the Court of Appeal rely in the judgment that this concept of exile. Now, we've seen before criticism made of by the courts of this notion of a homegrown criminal, but they seem to rely here on exile, where effectively he's been exiled from the UK, which is in effect his home country. So let's carry on. The effect of the exile of this young man with all his characteristics, attributes, qualities, and defects that were disclosed by the evidence. Not every healthy young man in a case such as this would make the same impression. However, this was a 19-year-old with a conviction when he appeared before the FTT. He had lived for all but the first 3 years of his life in the UK, had no connection to Jamaica whatsoever other than a residual nationality. The judge found he had a specific dependency on his parents. The judge was entitled to form his own impression of the obstacles he would face on being dumped in Jamaica at the end of the prison term. He was not an adult foreign criminal like some whose cases come before the courts with a significant foundation of knowledge of the country of his birth from an earlier time in life, and who is being returned to a country with which he has some acquaintance. It is not surprising to me that a judge, if not all judges, would find, as this judge did, that there were very significant obstacles to integration. Others might have made a different decision, but this was very much a case on its own facts to be assessed on the evidence. Now, of course, each case will turn on its own facts, on the evidence presented, and you've got to present good evidence to establish this test. But this is a really interesting paradigm example and a case well worth looking to, particularly this reliance on the notion of exile. What about if a client comes to you and they've had very poor immigration advice previously? So in Mansour, a decision of President Lane, a previous advisor had made an application for this client without withdrawing a pending permission to appeal application. So his application was treated as invalid much later by the Home Office, and he lost his lawful status in the United Kingdom. So what's the impact on that on Article 8? Now, in this case, he had complained to the OISC, and his complaint had been successful. So that's important, and you may need to complain about previous advisors if you're going to rely on poor immigration advice in terms of an Article 8 claim. So in Mansour, it says this: poor professional immigration advice or other services given to P cannot give P a stronger form of protected private or family life than P would otherwise have. So it doesn't strengthen Article 8.1. It doesn't strengthen the private or family life. But the correct way of approaching the matter is to ask whether the poor advice, etc., that P has received constitutes a reason to qualify the weight to be placed on the public interest. We're Article 8.2 now, in maintaining firm and effective immigration control. So it could reduce the weight to the public interest. It will only be in a rare case that an advisor's failings will constitute such a reason. So, it's going to be a rare number of cases, only a few. The weight that would otherwise need to be given to that interest is not to be reduced just because there happen to be immigration advisors who offer poor advice and other services. Consequently, a person who takes such advice will normally have to live with the consequences. So in general, just because you've had a bit of rubbish advice is not going to affect your Article 8 case. But rare cases it may do, and one of the examples is given in Headnote 4, a blatant failure by an immigration advisor to follow P's instructions as found by the relevant professional regulator, which led directly to P's application for leave being invalid when it would otherwise have been likely to have been granted, can however amount to such a rare case, and the appeal was allowed in this case. And I've relied upon that in recent times, so certainly a case to rely on. And you may, as a solicitor, need to lodge a complaint against former advisors in order to be able to have any purchase in making an argument on this basis. What about Article 8 outside of the immigration rules? So normally you're saying, well, my Article 8 appeal, because you can only appeal on asylum or human rights grounds, and in a human rights case, often you're saying, well, look, Article 8 is disproportionately interfered with because I meet the rules. What about outside of the rules? Well, the Home Office often talk about exceptional circumstances, but of course that's not the correct test. And a really helpful case and a helpful summary case on Article 8 is GM Sri Lanka back from 2019, where Lord Justice Green goes through Article 8, insurmountable obstacles, proportionality, and the little weight provisions in 117B. And he made at paragraphs 27 to 32, he makes sort of 6 general points on Article 8. And at paragraph 29, this is his third point in relation to Article 8 outside of the immigration rules. So if you can't meet the immigration rules, what's the test outside the immigration rules? Third, the test for an assessment outside the IR immigration rules is whether a fair balance is struck between competing public and private interests. This is a proportionality test, and he relies on Agiaco and Heshamali in order to ensure that references in the immigration rules and in policy to a case having to be exceptional before leave to remain can be granted are consistent with Article 8. They must be construed as not imposing any incremental requirement over and above that arising out the application of an Article 8 proportionality test. For instance, that there be some highly unusual or unique factor or feature. So you're not on the search for an unusual or a unique factor. Any references in the rule to exceptional circumstances in terms of Article 8 is the application of a proportionality test. That's really important and something you'll want to rely on in a number of circumstances. We've talked about 117B and those statutory Article 8 considerations, and particularly in 117B4 and 117B5, the little weight provisions, either where you're unlawful, and it would apply to your family life and to your private life, or when you're here precariously and little weight be given to your private life. Rupia was a case about private life. She was a carer for somebody, a Miss Charles, and looked after her and had built up a private life. And in the Rupia case in the Supreme Court consider whether there's any flexibility with these little weight provisions, because I've certainly had judges say to me, they've listened to my argument, they said, well, yes, that's all well and good, Mr. Pipe, but haven't I got to give little weight to all this private life that your client has built up? Well, 117A2 talks about that the tribunal must have regard to the statutory considerations. And what the Supreme Court said in Rupia, and I'm sorry about the small text here, is it says in the middle of the paragraph, it recognizes that the provisions of section 117B cannot put decision makers in a straitjacket which constrains them to determine claims under Article 8 inconsistently with the article itself. There's a brilliant sort of soundbite to lift out when addressing the statutory considerations. Inbuilt into the concept of little weight itself is a small degree of flexibility. But it is in particular section 117A2A, which provides the limited degree of flexibility recognized to be necessary in paragraph 36 above. Although this court today defines a precarious immigration status for the purpose of section 117B5 with a width from which most applicants who rely on their private life under Article 8 will be unable to escape. Obviously, you're precarious if you've got anything less than indefinite leave to remain. Section 117A2A necessarily enables their applications occasionally to succeed. It is impossible to improve on how, in inevitably general terms, Lord Justice Sales in his judgment described the effect of section 117A2A as follows. So this is paragraph 53 of what was said in the Court of Appeal in Rupia by Lord Justice Sales, as he then was. Although a court or tribunal should have regard to the consideration that little weight should be given to a private life established in the specified circumstances, it is possible without violence to the language to say that such generalized normative guidance may be overridden in an exceptional case by particularly strong features of the private life in question. So there are certain cases where your private life that you've built up is capable of being given significant weight, because this is a compelling case, and you can say, yes, the statutory considerations say little weight, but this is a case which you approach flexibly because of the particular strength of the private life in question. Now, I want to jump to what is family life, but this is really interesting, actually, because Llama, a case by Mr. Justice McCluskey when he was president, involved somebody who, similarly, Mr. Llama cared for a Mr. R, who was an actor who'd had a catastrophic accident. Now, Rupia was also a carer sort of case, but Rupia was only argued on a private life basis. But in Llama, it was argued on a basis of family life, that even though they weren't blood relatives, they had this profound bond that amounted to family life. Now, a lot of the case concerns the weight to be given to video recorded evidence, because that was relied upon in the appeal. But Mr. Justice McCluskey goes on to analyse the nature of Article 8 and says this, this is paragraph 32, thus, at its heart, family life denotes real or committed personal support between or among the persons concerned. Such persons need not necessarily be related by blood and, in that sense, are not a family in the traditional conventional senses. However, they are readily embraced by one of the dictionary definitions of family, namely a group of things that are alike in some way. Mere likeness is not, of course, sufficient for Article 8 purposes. The likeness in Article 8 terms is constituted by committed support, emotional bonds, and very frequently by a strong sense of duty. And he found Article 8 was engaged in this case. Now, I think because of Brexit, we're seeing a lot of appeals before the tribunal, particularly out-of-country entry clearance appeals involving EU law, EEA law in respect of dependency, so often Regulation 8, other family members, and trying to establish that they're dependent on the sponsor in the United Kingdom, who's an EEA national. So I've seen a lot of that. Now, dependency is a question of fact. It's about material support, and it must be to meet the essential needs of the appellant. We're going to look in a minute at membership of household, and in the case of Manecki, Mr. Justice Blake gave really helpful guidance on both dependency and membership of household. But in terms of dependency, I wanted to refer you back to a case of Gia back from 2007. It says this, the Court of Justice: the court has held that the status of dependent family does not presuppose the existence of a right to maintenance. Otherwise, that status would depend on national legislation, which varies from one state to another. According to the court, there is no need to determine the reasons for the recourse to that support. And I still see that in appeals and see questions on that basis, or raise the question of whether the person concerned is able to support himself by taking up paid employment. And I still see that raised. That interpretation is dictated in particular by the principle according to which the provisions establishing the free movement to workers, which constitute one of the foundations of the community, must be construed broadly. So that's a really helpful paragraph. And just to lead on from that, the Home Office guidance on EEA law dependency and this version 7, free movement rights, extended family members of EEA nationals version 7 is still, I checked today, the correct version when I'm recording this. The applicant does not need to be dependent on the EEA national to meet all or most of their essential needs. For example, an applicant is considered dependent if they receive a pension which covers half of their essential needs and the money from their EEA national sponsor which covers the other half. So that's the Home Office guidance. And I've seen them argue against that sort of position. So it's really useful in applications to cite that guidance. Well, probably not going to have applications now because of Brexit, but certainly in appeals. Another issue which comes up in EEA cases a lot is the whole question of marriages of convenience. Papa Georgi is cited there in this case, and Papa Georgi is a really helpful upper tribunal case. This is a case called Sadowska from the Supreme Court. It's a Scottish case. And Lady Hale says this: that must mean, as held in Papa Georgi, that the tribunal has to form its own view of the facts from the evidence presented. The respondent is seeking to take away established rights. One of the most basic rules of litigation is he who asserts must prove. It was not for Mrs. Sadowska to establish that the relationship was a genuine and lasting one. It was for the respondent to establish that it was indeed a marriage of convenience. So ultimately, the burden of proof is on the Secretary of State. And have a look at the Court of Appeal case of Rosa. That's also helpful. She goes on in paragraph 29 to say this: for this purpose, marriage of convenience is a term of art, although it is defined in the directive and the 2009 communication as a marriage, the sole purpose of which is to gain rights of entry and residence in the European Union. The 2014 handbook suggests a more flexible approach in which this must be the predominant purpose. So what's the predominant purpose? It is not enough that the marriage may bring incidental immigration and other benefits if this is not its predominant purpose. Furthermore, except in cases of deceit by the non-EU national, this must be the purpose of them both. Clearly, a non-EU national may be guilty of the abuse when the EU national is not, because she believes that it is a genuine relationship. Also have a look at paragraph 34 about interviews, because what Lady Hale says there is reliance must be placed on the consistent answers given in interviews, because often the Secretary of State will say, this is a marriage of convenience. Here's 10 questions out of the 780 they got wrong. But nobody looks at all the answers they got right. And I've had to appeal a number of cases on that basis. So do have a look at that. I mentioned Manecki earlier, membership of household, which is relevant to Regulation 8 of the 2016 regulations. And we're still seeing, even though we can't make new applications now under the regulations, we're seeing a lot of appeals coming through on this. Membership of a household has the meaning set out in KG, Sri Lanka and Bigia. That is to say that it imports living for some period of time, so some period of time, under the roof of a household that can be said to be that of the EEA national for a time when he or she had such a nationality. So if you lived with them before they got the EEA nationality, that's not going to count. It's got to be when they've got the nationality. That necessarily requires that whilst in possession of such nationality, the family member has lived somewhere in the world, in the same country as the EEA national, but not necessarily in an EEA state. And that's a quote from the head note of Maneki. One of the cases I love being instructed in sole responsibility cases. I don't know why, but paragraph 297, and that's sort of the classic case that has stood the test of time from 2006 is Professor Grubb's decision in T.D. Yemen. Let's go through his sort of 9 principles there. Who has responsibility for a child's upbringing and whether that responsibility is sole is a factual matter to be decided on all the evidence. So it's not just, often somebody will argue it just, well, I've got a court order. Well, no, it's a factual consideration on all the evidence. The term responsibility in the immigration rules should not be understood as a theoretical or legal obligation, but rather as a practical one, which in each case looks at who is in fact is exercising responsibility for the child. So who is the one who's got control and direction over that child? That responsibility may have been for a short duration in that the present arrangements may have begun quite recently. So it may be recently that, say, dad has took over sole responsibility, but that doesn't mean there's not sole responsibility. 3, responsibility for a child's upbringing may be undertaken by individuals other than a child's parents and may be shared between different individuals, which may particularly arise where the child remains in its own country while the parent involved in its life travels to and lives in the United Kingdom. So mum may have sole responsibility in the UK, but mum's relative may be the one exercising day-to-day care back home. Roman 4, wherever the parents are, if both parents are involved in the upbringing of the child, it will be exceptional that one of them will have sole responsibility. So if both parents, I've had recent cases where the other parent has still had contact, and it's only in exceptional circumstances the tribunal is going to say, well, there's sole responsibility. Roman 5, if it is said that both are not involved in the child's upbringing, one of the indicators for that will be that the other has abandoned or abdicated his responsibility. So has the other parent abandoned or abdicated responsibility? In such cases, it may well be justified to find that the parent no longer has responsibility for the child. However, the issue of sole responsibility is not just a matter between parents. So even if there is only one parent involved in that child's upbringing, that parent may not have sole responsibility. So granny may actually have responsibility for the child. In the circumstances likely to arise, day-to-day responsibility or decision-making for the child's welfare may be necessarily shared with others, such as relatives or friends, because of the geographical separation between parent or child. Roman 7, that, however, does not prevent the parent having sole responsibility within the meaning of the rules. So just because granny's on the ground doesn't mean that mum here in the UK doesn't have sole responsibility. Granny may be deciding whether they have Cocoa Pops or Rice Krispies in the morning, but it's mum here who's making the main decisions. Roman 9, the test is not whether anyone else has day-to-day responsibility, but whether the parent has continuing control and direction, that's the test, of the child's upbringing, including making all the important decisions in the child's life. And you need to be able to give examples of those in terms of all the important decisions. If not, responsibility is shared and so not sole. What about, we still see refusals on that there's not a genuine and subsisting relationship. And I thought it was worth going back to the decision of Mr. Justice Blake when he was president in the Goody case in 2012. There was a case I think he heard on the same day, which is also reported on a similar issue called NAZ, N-A-Z. Have a look at that. But he says this: it may be that the ECO and the judge considered that the requirement to show a subsisting marriage imposes some significant burden to produce evidence other than that showing that there was a genuine intention to live together as man and wife in a married relationship. If so, we conclude that that is an error of law. The authority of G.A. Garner only requires that there is a real relationship as opposed to the merely formal one of a marriage which has not been terminated. Where there is a legally recognized marriage and the parties who are living apart both want to be together and live together as husband and wife, we cannot see that more is required to demonstrate that the marriage is subsisting and thus qualifies under the immigration rules. Now, have a look at head note 3, because he talks about where there are no countervailing factors. So there may be countervailing factors in your case, which you have to prove more. But it lowers the bar, which sometimes the Home Office sort of up that bar in terms of what is a genuine and subsisting relationship. In terms of lockdown, I've been doing a lot of bail cases during lockdown. And one of the things I always rely on in bail cases in my submissions, and you might want to do it in your bail applications, is the Presidential Guidance Note number 1 of 2018, which is the guidance on immigration bail for judges of the FTT. And there's really helpful information in there. For example, look at paragraph 35, where it talks about a low risk of absconding, where there's a stable address, there's support or pending applications before the Home Office, or if there's a low risk of absconding, if there's no imminent removal, paragraph 36. Or about paragraph 57, about the Home Office not routinely seeking a residence condition if there's a stable address. But what about addresses? I wanted to, particularly paragraph 61, but I've put 60 and 61. In terms of addresses, the challenge to addresses mustn't be based on speculation or generic arguments. And in particular, often the issue is whether there's permission from the landlord to live at the property, or if somebody's on license, whether probation has approved the property. But paragraph 61 of the immigration guidance says that the tribunal should assume that permission will be given by the landlord or probation unless there is specific evidence to the contrary. So in general, the fact that you haven't got specific permission from the landlord or from probation shouldn't stop you getting bail in the absence of a sort of particular concerns about the address. Just finally, then, we've talked a lot about Article 8 and the immigration rules. What about where you satisfy the immigration rules? Well, TZ Pakistan and PG India is a really helpful case from the senior president of tribunals. Have a look actually at paragraph 28, where he talks about a proportionality assessment outside the rules and the relevance of delay, EB Kosovo, and meeting the immigration rules on entry clearance, Chikwamba. Have a look at paragraph 28, which is really helpful. But what about where you meet the rules? Well, he says this: where a person satisfies the rules, whether or not by reference to an Article 8 informed requirement, then this will be positively determinative of that person's Article 8 appeal, provided their case engages Article 8.1, for the very reason that it would then be disproportionate for that person to be removed. So as long as you've established family or private life, Article 8.1, if you meet the immigration rules, you should win your Article 8 appeal. Although the only caveat I would say there is where there are other factors in play, sort of like a refusal under the general ground. So say you meet the long residence tenure rule, but there's an ETS allegation, obviously that might outweigh in those circumstances. But unless there are these countervailing issues, say the general grounds, if you prima facie meet the immigration rules, you should win your appeal. As I said, I'll try and put these slides on the Number 8 Chambers website, but that I hope has been helpful to you, going through some cases, old and new, and some principles that you can rely on in your skeleton arguments, grounds of appeal, and representations. If you see my immigration law images online, feel free to save them, share them, use them, just don't alter them, all right? So thanks very much for watching this webinar today.